Welcome, everyone, and thank you so much for joining us this afternoon for the second speaker event of the 2025-2026 Rothenberg Healthcare Law and Policy Speaker Series. My name is Diane Hoffman, and I'm a professor and director of the Law and Healthcare program at University of Maryland Carey School of Law. This year's series has had a focus on the future of food, drug, and medical device regulation. And this afternoon's speaker is one of the top experts in the country in this area. We are thrilled to welcome Professor Patricia Zettler as today's guest. But before we hear from her and I introduce her, we want to welcome all of you and share a bit about this series. So if this is your first time joining us, a special welcome to you. This series, the Rothenberg Speaker Series, was launched during the COVID era when we were exercising social distancing as a way to we decided to do this as a way to keep connected. And it has since grown into a vibrant virtual forum. It's now in its sixth year, and the series continues to bring together leading health law scholars and practitioners, offering our community the chance to engage with the most pressing issues in health law and policy. So this work is made possible through the generous support of the Karen Rothenberg and Jeffrey Seltzer Law and Healthcare Program Endowment. Professor Rothenberg was the former dean of our law school and longtime director of the Law and Healthcare Program. She laid the foundation for this initiative, and we're proud to carry forward her vision. And now we're honored to welcome Patricia Zettler as our esteemed speaker. Professor Zettler is a nationally recognized expert on the U.S. Food and Drug Administration and Food and Drug Law. She is the John W. Bricker Professor of Law and faculty of the Drug Enforcement and Policy Center at the Moritz College of Law at Ohio State. Professor Zettler teaches courses related to administrative law. She teaches tort law, FDA law, and public health. She's also a prolific scholar and has published over 60 articles in scientific journals and traditional law reviews, covering a wide variety of topics such as stem cell interventions, opioids, cannabis products, tobacco and nicotine products, COVID-19 countermeasures, and non-trial access to investigational drugs, as well as citizen science. She's also a co-author of the fifth edition of the Food and Drug Law casebook that many law professors use to teach food and drug law. Her research has won multiple prizes, including the 2023 Early Career Distinguished Scholar Award at The Ohio State University and the 2015 Health Law Scholar Award from the American Society of Law, Medicine, and Ethics. From November 2023 to January of this year, 2025, Professor Zettler was on leave from Ohio State, where she served as Deputy General Counsel to the U.S. Department of Health and Human Services, covering the FDA portfolio. In that role, she helped to advance and implement key FDA regulations and policies. She worked with the Department of Justice on litigation involving FDA and advised HHS, FDA, and others across the federal government on a wide range of issues. Before her academic career, Professor Zettler served as an associate chief counsel in FDA's Office of the Chief Counsel. She also has held academic appointments at Stanford Law School and Georgia State University College of Law. Additionally, Professor Zettler has served on the Food and Drug Law Institute's Board of Directors, the National Academies of Sciences, Engineering, and Medicine's Health Sciences Policy Board, and the Ohio State Bar Association's Administrative Agency Law Specialty Board. So we are really very honored to have her with us today, and she'll be sharing her depth of experience and knowledge in today's talk on the topic of how FDA's crisis is everyone's crisis, the past, present, and future of FDA reform. And before I turn it over to her, I just want to say, if you, as she's speaking, have questions that come to mind that you'd like her to address after the talk, please put them in the chat. Thank you. And again, I turn it over to Professor Zettler.
Well, thank you so much for that very kind introduction. It is a real honor to be, virtually here with you all today and to be part of the Rothenberg Healthcare Law and Policy series. There are always so many wonderful speakers in this series, and there are so many wonderful students and faculty at University of Maryland, and so many wonderful Maryland alumni in the health law and food and drug law communities that it is just a real delight to be included and be here with you. So I'm going to go ahead and share my slides. Um, there we go. Just kick it off by saying, as Professor Hoffman noted, I'm going to talk about the past, present, and future of FDA reform. So FDA, like many federal agencies and like many federal health agencies, as I'm sure many folks in this audience are tracking, are in a time of tremendous upheaval. And so I want to think about what can we learn from what has come before? What kinds of reforms have come before to help us think about what might come in the future and how we might guide FDA reform in the future in ways that best serve its public health mission. And specifically, as I was mentioning before the talk started to Professor Hoffman, Holly Fernandez Lynch at University of Pennsylvania and Reshma Ramachandran at Yale and I just received funding from Arnold Ventures to do work to help think about what can that future of FDA reform look like. And I'll talk about that project at the end of the talk. And so in that spirit, as we're starting this work, we're really interested in what your comments and thoughts and questions are. So those will be really helpful for us as we're getting that work started. Before I get into the substance, I have two disclaimers. One is that although I am a lawyer, I am not your lawyer, which is to say that everything I'm saying today is for informational and educational purposes only and is not legal advice. And the second disclaimer is that everything I'm saying today are my own views and not necessarily the views of my employer, any past employers, or any grant funders. All right, so with my time today, I want to cover sort of four general ideas. First, I want to talk a little bit about why we have an FDA in the first place to help us think about why certain reforms have happened in the past and are happening today and might happen in the future. So why did we, the people, through our representatives in Congress, create a food and drug regulatory system? Now, FDA, of course, oversees lots of products, including food, drugs, biological products, devices, animal drugs, tobacco products, cosmetics, and altogether that covers about 20 or 25% of our consumer economy. But for the purpose of today, I'm going to focus on drugs as an animating example to think about the next three bullets. What have been the reforms of the past? What kinds of reforms are happening in the present? And how might we rebuild and re-envision an FDA for the future? And in particular, I'll talk about that proposal, that work I mentioned with Holly Fernandez Lynch and Reshma Ramachandran about a principles-based approach to re-envisioning FDA. And there'll be lots of time for questions and discussions at the end. So again, I'm really looking forward to that part of the talk. And I understand also that there'll be some great speakers coming later in the year that'll talk about other areas of FDA regulation, including food and devices. So I encourage you all to attend those other talks as well. Okay, so why do we have an FDA? Well, FDA is a public health mission. In 1997, Congress codified FDA's public health mission in the statute, and essentially FDA is here to protect and promote public health. So why do we need a public health agency like FDA? And there are different kind of times in the past or different laws that have been enacted that people point to as the starting points of the food and drug regulatory system or food and drug regulation as we know it today. And one time in the past people point to is the 1906 Pure Food and Drugs Act. So why in 1906 did we, the people, through our representatives in Congress, decide we need a national food and drug regulatory system? Well, in short, we came to understand that food could be harmful and gross, right? So one thing people point to as the motivating push for that 1906 law, or the thing that gave gave the political will for that 1906 law is Upton Sinclair's novel, The Jungle, which talks a lot about the Chicago meatpacking industry and the unsanitary conditions that were in place at the time. And around the same time, there were also concerns about poisonous preservatives and dyes in food, something we still hear about today, right? About false or misleading claims about cure-all products and about harmful or dangerous drugs. So that 1906 law said you cannot distribute misbranded or adulterated food and drugs in interstate commerce, but it did not create any pre-market approval authority for drugs or other medical products. Congress began to change that for drugs in 1938 when it passed the Federal Food, Drug, and Cosmetic Act. And that law was passed after a disaster where elixir sulfanilamide that contained the poisonous solvent diethylene glycol killed 107 people, including many children. So at that point, the FDA in 1938 got the power to review drugs for safety before marketing. But it wasn't until 1962 that Congress required that drugs not only be shown to be safe, but also be shown to be effective before marketing. And that change to the law came on the heels of learning that thalidomide, which was a drug that was marketed in many other countries, though not in the United States, thanks to an FDA medical review officer named Frances Kelsey, that drug had caused severe birth defects in many people. So we have this history of some products that just don't work, some products that are sort of claimed cure-alls, and some products that can be harmful. And this kind of tees up an understanding of why we have FDA pre-market review authority for drugs. FDA has a lot of powers over drugs from sort of the beginning of drug development through post-market monitoring. But in terms of pre-market approval, we can think of that as serving a few goals. One is that consumer protection goal that makes sense given the history I was just talking about, that requiring pre-market approval based on safety and effectiveness physically protects people from unsafe and ineffective products. But that pre-market approval requirement also serves an important innovation function in that it compels the production of robust scientific evidence about what a product actually does. And that evidence often wouldn't otherwise be produced because, as those of you in the audience who may be scientists or clinicians know better than I do, because it's expensive, time-consuming, and difficult to create that evidence. And where FDA lacks pre-market approval authority, like over the dietary supplement market, we often see things sold with little or no established biomedical or scientific basis for the claims that are made about them. So to paraphrase a former FDA commissioner, Margaret Hamburg, it's not innovation if it doesn't work, right? So there's this information production innovation function that FDA serves in the drug context. And that information production function also serves a patient autonomy role. Faced with serious diseases and sometimes quite limited or no treatment options, some patients understandably are willing to try uncertain but promising interventions. So you might wonder, how is it possibly the case that it's autonomy enhancing to require pre-market approval to essentially take that choice away from them? As a preliminary matter, the approval process today doesn't actually take that choice away. Current US law permits access to experimental interventions through clinical trials, through FDA authorized expanded access programs, or through programs under the Federal Right to Try Act. But what is not permitted is for companies to sell and commercialize interventions for profit without first demonstrating that they work. And it's allowing that kind of commercialization that arguably, rather than empowering patients, would diminish autonomy by robbing patients and clinicians of the evidence they need to make informed treatment decisions. So in other words, this regulatory process that we have takes time, to be sure, but it's not mere red tape. It's not really the regulatory process per se that makes it a time-intensive process to find genuine treatments for diseases. It's that it is scientifically difficult to identify things that actually address disease in a meaningful way. So part of the reason I'm talking about approval is that we often think about approval decisions as scientific decisions, and scientific evidence and expertise play a big role in drug approval, and rightly so. Congress set out a standard for approval in FDA statute that uh, requires that FDA make approval decisions based on safety and effectiveness, which in turn requires scientific evidence and scientific expertise to evaluate that evidence. And under existing FDA policies, scientific experts are supposed to take the lead on these decisions. Product approval decisions are delegated to expert career staff. And these procedures are part of the reason that FDA approvals have generally been considered trustworthy. Not perfect. Certainly, there are approvals that people criticize, but generally trustworthy. But the reality is that scientific evidence and expertise cannot do it all, right? That it can't answer all the questions that public health regulators like FDA face. FDA, in addition to relying on scientific evidence, which it absolutely must do, also has to make normative judgments as a central part of regulation, including judgments about what quantity and quality of evidence is sufficient, what risks are acceptable in relation to benefits, and how much uncertainty to tolerate. It also must make some sort of first order questions about what should it actually regulate, where should it actually enforce requirements. And science alone can't answer those questions, right? Reasonable people will disagree and have different opinions about where the right lines are to draw. So one way to think about FDA's job then is that it has to make timely, scientifically, and politically informed decisions that serve its public health mission and serve the American people, but that also must withstand scrutiny from a whole bunch of folks, right? From industry, advocacy groups, elected officials, judges, patients, clinicians, scientists, and the public. And to be clear, before I go on, when I say FDA must make political decisions, I don't mean partisan political decisions. I mean that there are these normative judgments baked into the decisions regulators must make. And so they are political in that sense, and that there are these non-scientific normative calls that the agency must make. So against that background of inextricably intertwined scientific and normative decision making, paired with the really prominent role that FDA plays in regulating the products that Americans use every day, it's unsurprising in the end that FDA has been the subject of substantial political attention and reform since its inception. So, for example, if we are sort of looking back on the reforms of the past, the Federal Food, Drug, and Cosmetic Act has been amended about 300 times since 1938. And some of those amendments are relatively minor, but a lot of them are pretty significant. For instance, legislation has enlarged or shrunk the scope of FDA's jurisdiction. It has expanded, limited, or restructured the authorities that FDA has over the products within its jurisdiction. It has created regulatory and financial incentives to promote the development of generic drugs or medical products for certain disease areas like orphan diseases or rare diseases. It has increased agency funding through charging industry user fees to allow FDA to better respond to the growing landscape of therapeutic products, and so on. So there's been a lot of change through Congress, but Congress isn't the only source of reform for FDA. Sometimes reform has come through lawsuits, whether specific to FDA or about broader administrative law or constitutional issues that affect FDA. For example, FDA issued a rule last year clarifying its authority over laboratory developed tests, a certain kind of diagnostic. That rule was challenged and then vacated by a court earlier this year. Sometimes state efforts have driven change at the federal level, whether through federal legislation or through FDA using the powers it has in order to address whatever concern is bubbling up from the states. One example of this would be that over 40 states passed what are known as right to try laws before in 2018 a federal law was enacted. And this was a law that created a pathway, an additional pathway to those that already existed for patients for companies to provide unapproved investigational products outside clinical trials to patients. And FDA itself, the agency itself, of course, often implements reforms when it has the legal authority or flexibility to do so. So one example of this might be when FDA reorganizes, as it did a few years ago, to create the Human Foods Program within the agency to sort of better prioritize food or sort of better improve its approach to food regulation. And across all these areas of reform, sort of no matter what the source of reform is, there have been some enduring themes that come up about how FDA can best advance public health, and some enduring ideas that seem to be motivating these reforms. Some of these themes are around how the agency operates in general, like concerns about independence from industry influence, independence from political influence, about efficiency. Is the agency moving fast enough? About transparency, about the agency's openness to public comment or patient engagement. There also are sometimes more specific concerns about particular product areas. So if we think about drugs or biomedical products, there are concerns about whether FDA is sufficiently ensuring the safety and effectiveness of those products. Is it requiring enough safety and effectiveness evidence, through its approval process? Is it encouraging innovation? Is it requiring too much evidence of safety and effectiveness, and so slowing down access? Is it doing enough to support patient access? Those kinds of questions that are more specific to the biomedical product context. And these themes about how FDA should operate that have motivated reforms at FDA, whether to its statute or within the agency to how it implements those authorities or so on, these themes sometimes are in conflict with one another, right? So our visions of how FDA should operate can be conflicting. And accelerated approval is one example of that. Accelerated approval is when the agency approves a drug based on its effect on an unvalidated surrogate endpoint, rather than based on evidence that the drug has an effect on a clinical endpoint. And after that approval, companies are required to conduct confirmatory trials to confirm that the effect on the surrogate endpoint actually leads to a clinical benefit. And the accelerated approval process is one that FDA created by regulation amid the AIDS crisis in the 1980s and 1990s, and one that when patients were advocating for, they were advocating for faster approvals, among other things. After FDA created accelerated approval through regulation, Congress then put it in FDA statute. So Congress codified that in 1997. And in many ways, we can think of accelerated approval as a success. There have been a lot of accelerated approvals, and patients have gotten access to drugs faster than they might otherwise have in certain instances. But at the same time, how FDA has implemented accelerated approval has been contentious. In the last 10 years, there have been a number of FDA approvals through this accelerated approval process that have been criticized for being based on too little evidence. And FDA has also been criticized for not enforcing requirements for companies to get that confirmatory evidence after approval, while at the same time, the agency continues to be criticized for not moving quickly enough or being too risk averse with respect to its approvals. So accelerated approval offers a good example of this, not only the enduring themes that come up when thinking about FDA reform, but the enduring tension between some of these themes, such as the tension between patient protection and access, the debates over evidentiary sufficiency, and concerns about negatively impacting innovation or industry investment that tend to come up. Given all the political aspects of FDA's work, or all the normative aspects of FDA's work, I think it's reasonable and consistent with democratic accountability that the agency's priorities and approaches would change from administration to administration and have changed from administration to administration. But even acknowledging that um, historical kind of shift between administrations, different approaches to FDA, and even recognizing that there is this long history of sort of constant reform and evolution at FDA. I think many folks would say what has happened in the last year at the start of the second Trump administration seems to stand apart from what has come before. And there are a number of examples of this. I'll, offer a few, and here are some of the headlines that have been published in the last 11 months or so. I think one example of this is the loss of agency staff and expertise. ProPublica reported that as of August, FDA has lost over 20% of its staff. Those who've been forced out or left include a lot of the core career staff who perform critical functions for the agency, like facilities inspections and things like that, as well as career senior leaders, including the directors of the Drug Center, the Biologics Center, the Tobacco Products Center, the Veterinary Medicine Center, the director of the Human Foods Program, and the chief medical officer at the agency. And this is a really big organizational difference. Those career senior leaders typically were a pretty steady group that would last across administrations. So this is a big change at the agency, this reduction in staff, a reduction in institutional knowledge, and reduction in sort of consistent leadership. I think another example of things that have been pointed out as a sort of new and different from before kind of reforms are reports of unusual, if not unprecedented, involvement of political appointees in product approvals, including product decisions about COVID-19 vaccines and some of the more recent announcements about acetaminophen, which is the active ingredient in Tylenol. Acetaminophen labeling. Sorry, my other laptop is ringing. About acetaminophen labeling, and so on. So there have been reports that political appointees have been more involved in these individual product decisions than they were in the past. As I mentioned earlier, FDA's policies delegate those kinds of decisions to career staff unless they're historically, unless there was an internal scientific dispute. There's also been a move away from using formal policy processes in open public forums. So there have been very few advisory committee meetings in the last year. And instead, the agency has held other kinds of meetings that have been described as CEO roundtables or expert panels that don't have the same, are not subject to the same conflict of interest examination and transparency and openness for public comment that advisory committees are, for example, because of the Federal Advisory Committee Act. And this, I think, is troubling for various reasons, but I think it's troubling even if we might agree with with the substance of a particular policy. And one example of this would be just last week, FDA leaders announced that the agency would approve certain drugs based on a showing of a plausible mechanism of action. And this announcement was made in a medical journal article rather than going through one of these sort of more traditional policy processes like rulemaking or issuing guidance that is subject to public comment. And the announcement for this approach to approving drugs based on a plausible mechanism of action might make a lot of sense for individualized therapies for ultra rare diseases. But without a policy process, the public doesn't get a chance to weigh in on the trade-offs the agency might be making, those kinds of normative calls the agency might be making. And the public and industry stakeholders don't really get a chance to understand what products exactly will be eligible for this, what are the guardrails out there for this program, and so on. At the same time that there are a lot of concerns being raised among the public health community and other stakeholders about many of the changes that have been happening at FDA over the past year, a lot of the messaging is really quite consistent with the kinds of messaging and kinds of themes we've seen throughout the history of FDA reform, right? So FDA leadership is describing their many of these reforms as tied to commitments to gold standard science or transparency or protecting American consumers or accelerating cures or increasing public trust or modernizing the agency. And all those things sound like good things, right? They sound like the kinds of things we all want FDA to do. So, against that sort of long history of reform, this current moment we're in, we might wonder, where does that leave us, right? What is going to happen going forward, and how can we shape what might happen going forward in a way that is beneficial for the American people and for public health? So I don't think we can deny that FDA will, for the foreseeable future, likely be operating in a relatively grim political environment in which mistrust in public health and scientific expertise may persist. And FDA is going to have that decimated workforce I was talking about that will be difficult to rebuild. And it will, as it always does, be facing emerging technologies that may not fit within existing regulatory systems in a neat way or may pose new or difficult scientific questions. So that all sounds bad, but I don't want to end on a total downer. So I do want to talk a little bit about the work that I mentioned that my colleagues and I will be doing. Um, so this, you might wonder why there's this old picture on a slide about reforms of the future, but this is a picture of President John F. Kennedy signing that 1962 law that created the modern drug approval standard after thalidomide caused birth defects in dozens of countries. And so this is just sort of a way of reminding ourselves that that FDA's history is one of reform in response to crisis or significant change. So the current moment we're in, just as previous moments have done, may present opportunities to re-envision how food and drug regulation works, how we want it to work, what we want that regulation to look like. So what do we do, right? How do we think about what we want that regulation to look like? And how do we navigate the inherently intertwined political and scientific nature of FDA regulation and these conflicting visions of how the agency should best serve the American people and what it needs to do its job well? Like, how can we decide which reforms are worth pursuing, are sort of within the bounds of reasonable disagreement from administration to administration, and which ones are out of bounds and not acceptable for the agency to pursue? Well, one answer to that dilemma is to clearly articulate a set of core principles that underlie FDA's public health mission. These principles could provide a roadmap of sorts for FDA decision making, a framework for explaining FDA policies and actions to the public, and a way to assess FDA's successes and its failures. And there will be failures, right? There's never going to be a world in which we all each individually agree with everything an agency does, nor that an agency can operate perfectly. But in many ways, FDA is already principles based. We see that in that history of reforms. We see the same kinds of ideas pop up over time. And we see that right now, right? We see the current FDA leadership call on those same kinds of ideas about transparency and scientific integrity and innovation. But an explicit accounting of what FDA's core principles are or should be, and clear definitions of those principles, and a set of metrics for assessing whether and how well they are being achieved aren't really things that are publicly set out. In other words, we don't really have a Belmont report or an Asilomar conference or something along those lines for FDA. And it definitely does make one sound probably too big for one's britches to suggest doing something like that. But this is along the lines of what Reshma, Holly, and I are working on right now. And specifically, as I mentioned, with support from Arnold Ventures, we're doing two things to develop this kind of accounting of principles. One, we're looking at major FDA reforms to date to understand the landscape of policy options that have been considered, identify more comprehensively the themes motivating those reforms, and to look at the relationship between reforms and public health outcomes. And the idea is that having an expansive understanding of what has already been tried, what has already been proposed, can help us have a better understanding of what we might want to try in the future and how we might conceive of FDA's appropriate role in the future. And the second piece of the work we're doing is conducting a Delphi study of experts in the area, in the area of FDA law and policy, to think through where is there consensus about what the core aspects of FDA regulation are, where is there consensus about how we might define those principles or core aspects of regulation, and where is there a lack of consensus? Again, to sort of help envision how we might think about reform moving forward. Now, principles are, of course, no silver bullet. The point is not that they're binding or that they can be applied algorithmically, but rather the point is to think about a central framework to help outsiders assess what the agency is doing and also help the agency and lawmakers explain the trade-offs they are making in particular policy choices to the public. And these can be, there are opportunities for reform that are on the near horizon, including upcoming user fee reauthorization legislation. For those in the FDA weeds, know this is sort of must-pass legislation that comes around every 5 years. And of course, we will have elections in the future and shifts in administrations in the future, and even current FDA leadership might be persuaded by some of these ideas. So I will end there with some acknowledgments to co-authors on some projects over the last year, and of course, an acknowledgement to Arnold Ventures. And again, I want to thank you all for being here and for your time and for the gracious invitation to be part of this wonderful speaker series.
Wonderful. Well, thank you. Thank you so much for this fascinating talk. And I'm really excited about the projects that you are going to be working on. That sounds like it will really be useful for people who are, trying to figure out, is FDA doing a good job or not? So we have about 20 minutes for questions. So if anyone has any, please feel free to put them in the chat. I guess I can start by asking something. So, you identified the tensions that exist, that have historically existed in FDA policy. And of course, one of the big ones is safety versus access and early access. And additionally, it seems like it's been a main focus. And it seems like historically FDA has gone through like ebbs and flows in terms of, or the pendulum has switched back and forth as to which of these have had, it has emphasized. So first of all, I'm wondering if you agree that it seems to be at this point, the pendulum is towards early access. And I know lots of these accelerated approval and just getting things out to the public as quickly as possible. And this, I think, was even preceded, certainly the Trump administration and also just generally deregulation of the agencies. But even, earlier administrations also have focused on earlier access. And so I'm wondering what, is 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 this simply something that is, industry pressure? Certainly pharmaceutical companies want to see want to have to go through less hurdles and want it to take less time because it's very costly for them to do all the testing that they do. But is there anything else going on, do you think, in terms of trends in the country, in terms of the consumer mindset about health and safety and government, that is affecting that? And I mean, I can't really think of, maybe you probably can because you're more familiar with this area, but recent legislation that's focused on safety as opposed to efficiency or acceleration of the processes.
Yeah, I mean, so I think you're absolutely right that there is this sort of pendulum swing where, maybe there's some event that happens that is a lot of people are harmed by a particular drug or medical product, and the focus gets more on safety. And then, maybe we swing back the other way and get more focused on patient access. But I do think in the last, I don't know, 10, 15 years, a lot of the legislation that has been proposed, as you noted, has been focused on efficiency. I will give a shout out to Louis Grossman's book. I'm looking at it because it's on my desk over here to get the title right. Choose Your Medicine, Freedom of Therapeutic Choice in America. I'm blurred, so you can't see it. Louis is for folks who don't know him, is a historian and law professor who studies FDA law and policy. But in his book, he talks about this idea um, um, uh, of freedom of therapeutic choice as a historical trend in the US. And so it's actually more of an aberration that we ever decided to do something like pre-market approval. So it may be that, there just is this existing trend in the US that pushes back against the idea of requiring the production of robust evidence before marketing. So I'm not sure if that answers your question directly, but I think the other thing I would add is that I think those are the normative calls, right? About how much evidence do we want, how robust of effectiveness evidence do we want, how robust of safety evidence do we want at the point of approval, because there is no reasonable drug development program that can give us 100% certainty in a reasonable time frame at the point of approval. We're just never going to have that. So we have to make some kind of call. And I think it's okay. I personally think it's okay if different administrations make that call differently, as
Mhm.
long as they're transparent about what the trade-offs are, right? So that if we're requiring more evidence, that means that, you know, patients who may have to wait longer for insurance reimbursement, and which is sort of the way, we get payment after approval. And if we are asking for less evidence, we may lose out on innovative products. There may not be sufficient incentives to develop products that really work. We may, sort of get stuck. Whatever the trade-offs are, as long as we're transparent about them, I think as a policy matter, we could choose to make different trade-offs, even if I personally have my own view about what the right trade-offs would be. So that was a long-winded way to say I think, there is absolutely the swing. Some of that maybe is just part of the swing of how we as sort of a political body think about the right kinds of trade-offs. Maybe some of it is about this historical trend of sort of health libertarianism in the United States.
Thank you. So I think we have some questions in the chat. So uh, Sanaya Shanoy says, thank you for a wonderful presentation. Could you speak about FDA's use of regulatory flexibilities, particularly with rare disease drugs, and whether the one area of reform may include offering more clarity on when these flexibilities are exercised?
Yeah, I mean, I think that's a great question. And that is, I think the focus on rare rare diseases have been an area where there has been a lot of focus in the last, again, decade, 15 years, longer probably. And I think part of that is because it is a difficult problem to develop evidence of effectiveness in rare disease populations. And to get products to market, and that's the way we get things in the US, right? So that's sort of the what we have to do. And I think, one, I haven't thought about it a lot until you asked this question, but I think that is, maybe that is a great area for transparency to be more, for the agency to be more transparent itself, or for Congress to require it, or for whatever the mechanism of reform would be about how the agency is using its flexibility to decide what quantity and quality of evidence is needed for any given drug to get approval. I mean, there is some of that transparency already through when advisory committees are used, you might get a sense of it. The agency does publish its internal review documents when it approves a drug, but it's not transparent, maybe not salient, even if it is transparent, maybe not salient to the average person who is seeking to understand what's going on. And I mean, and I think maybe part of your question is also about how much flexibility does FDA have under the law for rare diseases. And I think there have been some proposals, in particular, I'm thinking about the Promising Pathways bill that has proposed a pathway for conditional approval. So it would be rather than accelerated approval, would be a more true conditional approval where a product would have approval for a limited amount of time, and then the approval would go away if there weren't confirmatory evidence of effectiveness, but the standard is quite low for that conditional approval. But I think there are some of the criticisms of that bill have been that FDA already has a lot of flexibility. Like, how much more flexibility does it really need? And so that might, I'm not sure if that was also part of your question, but I think that is right as a legal matter, that FDA does already have quite a bit of flexibility to decide for any given product what counts as safe and effective.
Thank you. We also have a question from Pamela Kohlmeyer. She asks if you can comment on the politicization of mifepristone and gender-affirming care treatments, claiming safety concerns, even though the standard of care supports both.
Yeah, so I mean, I think this is, so for right now, at least from an FDA perspective, nothing has changed about mifepristone. And for, I assume most folks know, but for those who may not, mifepristone is the drug that is approved for pregnancy termination. And it is also subject to what's known as a risk evaluation and mitigation strategy, which is essentially like a risk mitigation program that FDA can require beyond labeling. So, maybe your doctor has to give you certain information, or the pharmacy has to confirm certain things before dispensing the drug, that kind of thing. Right now, nothing has changed. The drug is still approved, and the drug still has the same REMS, risk mitigation program requirements it had last year. So, but there has been a lot of conversation about, or a lot of comments from political leaders at HHS, including the secretary, and FDA, about doing a safety review of the drug. If I were a litigator, I would say those comments about political leaders making decisions about the drug might be good evidence, should something change, that I can make an argument that the decision was arbitrary and capricious and not based on the criteria in the statute. So, I'm not sure that there's much to say other than I agree that there is this politicization going on around certain products, including mifepristone. I think it is unfortunate for all kinds of reasons, but one reason is that whatever happens with mifepristone could have impacts on drug regulation writ large, and that way in which the sort of political environment around abortion might distort drug regulation more broadly is sort of yet another harm to that politicization. With gender affirming care treatments, there the products used for gender affirming care are not currently approved by FDA for that use. So don't disagree with what you're saying, but it's not really it FDA isn't in the mix there in the same way right now as it is potentially with mifepristone. And I think that's why one reason probably why there hasn't been the same kind of litigation against FDA that there has been in the mifepristone context.
Um, okay, we have another question from Catherine Feely, who says that FDA's mission traditionally centers on ensuring the safety and effectiveness of products that provide some benefit to consumers, but she works in the tobacco and nicotine product space, and here the agency is regulating products by definition that confer no health benefit and in many cases cause significant harm to consumers. I was wondering if you could speak to this regulatory paradox and how reform in this context might look in your opinion.
Yeah, that's a great question, and I will mention I am part of Ohio State's Tobacco Center of Regulatory Science, so a question that is near and dear to my professional heart. Um, I think it is a real challenge to regulate in the tobacco and nicotine space in for the reasons you note that they are just different kinds, they're products with different kinds of attributes than historically have been under FDA's purview, right? We might disagree about what it means for a drug to be safe and effective, but drug companies want to sell safe and effective drugs. FDA wants drugs to be safe and effective. Food companies want to sell safe food. FDA wants food to be safe. Again, you might disagree about what it exactly that means, but everyone's kind of aligned on the same goal. Whereas tobacco and nicotine products are a little bit are differently positioned on that front. In terms of what reform in that context might look like, I think it is kind of a shorter timeline too, because FDA has only had authority since 2009. So it's a little bit harder to, there's been sort of less opportunities to look back at what has happened before and how have we changed to make things better or potentially worse, and use the past to inform the future in that way. And right now, current FDA leadership has not really focused on tobacco and nicotine, or at least we don't really have a great sense of what their priorities are beyond preventing the importation of illegal Chinese vaping products, which is, obviously smoking is still the leading cause of preventable death in the United States. So that's a lost public health opportunity. So that was a long-winded lawyerly non-answer to your question, which I guess I could have just said, I don't know. I'll have to think about it more, but it's a good question.
Here's another from Sanaya. She wants to know about the use of post-marketing commitments and requirements. She says, I know there are criteria that the evidence must meet to qualify for a PMR. However, if the drug is not tested in certain populations, for example, pregnant women, there may not be enough data to warrant a PMR. Do you think that the criteria must be relaxed to enable more PMRs and therefore more post-market observational data for populations that have limited evidence?
Yeah. So post-marketing commitments and requirements are certainly a challenge. I have not thought about this question about certain populations and how whether there's enough data to warrant a PMR. I do think FDA as a legal matter has a fair amount of flexibility to say we have some signal of a safety risk, and so we're going to require something, even if it's, an observational study rather than a post-market trial, or to look at real world evidence or try to require the use of real world evidence in that way. Whether it's a good use of I think there are challenges like agency resource challenges because it is so difficult to enforce in the post-market context. But sorry, I'm just reading your question. I don't know that the criteria are too stringent, and that's why we don't see more post-market data. My suspicion would be that it's the practical difficulty of getting companies to actually do it, but that is another good question that I will give more thought to. And I appreciate you raising it.
Um, since I don't see another question here, I'm gonna take the prerogative, the moderator's prerogative, and ask a question, maybe the last one. So just picking up on something you said in response to the last question about real world evidence, I'm just wondering, do you have any sense about how often this is really FDA is really allowing drug manufacturers to use real world evidence in the context of drug approval? I know I just reviewed their proposed guideline on um, production of non-opioid pain relievers for chronic pain. And the 21st Century Cures Act, I believe, sets out that they can use, or the Support Act, I'm sorry, was the one that actually directed FDA to come out with this guideline and does direct them to use real world evidence. But even in that guideline, they don't appear to really um, do that. I mean, a bit, but it's not really fleshed out very well.
Yeah, it's I think it's still a very I think there's still a lot of questions about what kind of evidence can actually be gained from real world evidence. And in a different setting, when I was on a sort of continuing legal education panel for largely, folks at firms or at drug companies, one thing we talked about was like this would be a great time to try to pitch the agency on what you think are the actual effective uses of real world evidence, because it does seem like it's still, even though this has been in statute, as you mentioned, at least since 2016 and the 21st Century Cures Act, it does still feel like a moving target of what exactly can we use real world evidence for. I don't know the empirical answer of how many approvals there have been based on real world evidence, but someone should do that empirical project and look at that. That's a great idea. Yeah.
All right. Well, thank you so much. Really, we so appreciate you sharing your time and expertise with us, and your new project. It sounds very exciting, and it's very clear that this field will continue to evolve in fascinating ways. Um, and so we also want to thank Karen Rothenberg for her generosity in terms of funding the series, and to Jihan Gergis, our program specialist, who helps us skillfully coordinate these events, and Rebecca Hall as well for her assistance putting these programs together. We hope you all have a wonderful Thanksgiving and winter break, and will join us again in the spring. And thank you to Patty for also giving a plug to our future speakers, who include Peter Laurie, who is president and executive director of the Center for Science and the Public Interest, and he'll talk about future regulation of food by FDA. He'll be speaking on January 29th, and Reshma Ramachandran, who's an assistant professor and board certified family physician and health services researcher at Yale School of Medicine, who will be speaking on laboratory developed tests and their regulation on April 30th. So look for more information from us about these upcoming talks, and thank you so much for joining.
Thank
Take
you
care,
all.
everyone.
Thank you.